Appeals Division 1 is now in session.
Please be seated. This is the time set for argument in our cause number 1CA IC220038, Western versus Zerby. Council, we've reviewed the record and the briefs. We've discussed this matter at conference this morning. Both sides are granted 20 minutes for argument. I would remind appellants that if you want to reserve any time, it's incumbent upon you to make sure that you've reserved it. As you step forward to the podium, would you please announce your name and the party for whom you represent? And with that, we'll begin.
May it please the Court, my name is David Lundmark, and I represent the petitioners, Western Millwork and Cincinnati Insurance Company, and I would like to reserve about 3 minutes for rebuttal. The Commission's award should be set aside. COVID-19 is a common disease to which the general public is exposed, and as such, it is not compensable under Arizona's laws pertaining to occupational diseases. To show that a disease is compensable, a claimant needs to establish two basic elements. And the first is some special exposure to that disease in excess of the common population, and second, causation. And here, Zerby has not shown either of those elements. To show exposure in excess of the commonalty, or the commonalty rule as it's called, a claimant has to show that his exposure to a disease at the workplace exceeded the exposure to that disease experienced by Arizona's population at large. Stated differently, as this court put it in the O'Connor case, a disease is not compensable if the claimant lives in a geographic area where that disease is prevalent. Importantly, the relevant comparison here is between the workplace exposure.
Those cases, just so we're clear, those cases are valley fever cases, correct?
O'Connor is a valley fever case, yes.
All right. And you can get valley fever anywhere just walking down the street. You could get COVID that way.
That's correct. The mechanisms of transmission are different.
And there were a lot of businesses that took that into consideration and told their employees to stay home, right?
Yes, Your Honor.
And work from home. So they took the precautions to make sure that there wasn't this COVID transmission at the workplace, right?
Yes, Your Honor.
So isn't that distinguishable from the valley fever case?
Well, the evidence here is that Western Millwork did have safety precautions in place to prevent transmission, doors closed, mandating mask wearing. But I don't think that that's really the pertinent issue here. I don't think the mechanism of transmission is what is the grounds for distinguishing between these diseases. For instance, there's the Montgomery versus Industrial Commission case, which involved a very different mechanism of transmission. In that case, the petitioner was infected with Lyme disease when he was bitten by a tick on a work trip to California. It would have been very easy for the court to affirm just on the grounds that, well, he got bit by a tick while he was at work, therefore it's compensable. But the court didn't decide that. They went through the entire commonalty analysis and saw that there was evidence that this particular tick did not live at all in Arizona, therefore Arizona's general population was not exposed to Lyme disease. And so when he went to California, and he was, that automatically increased his exposure to that disease in comparison with Arizona's general population.
But was there anything particular about his job in Montgomery that exposed him to the tick? Because anyone could go to California and get bitten by a tick, and so you could make the argument, well, if you're at work and you get bitten by a tick, there's no greater risk of that happening than just going to California on vacation and getting bit by a tick, and so this doesn't satisfy the commonalty requirement.
Respectfully, Your Honor, I disagree. Under the commonalty requirement, you're looking at the geographic area where the petitioner lives. If his work requires him to go to another area where a disease is endemic or is common, that increases, that satisfies the commonalty rule. If you live in an area where there is no such disease and your work requires you to go somewhere where there is a disease, then that would make your exposure to the disease work-related.
Well, if you take that logic, you could say Mr. Zerby resided in his home where there was no COVID, and the job required him to go on site where there was COVID.
In this case, though, the comparison is not between the individual's private exposure to a disease and his exposure to the disease at the workplace. The comparison is between the exposure of Arizona's general population to a disease versus the exposure at the workplace. And to be compensable, that workplace must show that the exposure is it exceeds that of Arizona's general population.
But what case says we have to, when we're considering geography, that we have to consider it on a statewide level versus a county level or a neighborhood level or house by house level?
Well, there's no case that that cuts it down that precisely. I think an analogy, though, is the O'Connor case. This is another Valley Fever case, where it was shown that that there was some evidence presented that there were exceptionally dusty conditions on a weekend when the applicant was supposed to have gotten Valley Fever. But then there was also evidence that he lived in an area where the dust was present and took trips through areas where this dust was present. Similarly here, right, there may have been some excess exposure to the disease with this conversation with a coworker, but the evidence is also there that he lived in an area that was experiencing a COVID-19 pandemic, that the state was rife with COVID-19, and that he took trips and dined in public.
Aren't we bound by the determination that he did acquire the disease at work? I mean, all of those, that's a factual determination, and aren't we bound by that?
It is true that the presiding judge's factual conclusions are entitled to deference. This brings us to the causation issue. I will say this, that even if all of the evidence is construed strongly in favor of the applicant, their best case is that Mr. Zerby had a 15 to 30 second conversation with a coworker from a distance of 6 feet, and that this gave him COVID.
Who said 15 to 30 seconds?
Could be 30 to 60 seconds. It was about I believe the evidence.
I mean, there was a couple of texts, or I thought Mr. Zerby told his wife that he actually met twice.
There is only evidence in the record of a single conversation.
How is that not in the record, what I just relayed to you? How is that not evidence? I mean, I understand it's hearsay, but hearsay apparently is admissible, at least in some instances, and especially in these types of cases.
That's, Your Honor, that's...
So that would be two 15 to 30 second conversations to be taken. And I thought the other individual who overheard the conversation briefly didn't know how long it was. In fact, it said it could have been a few minutes.
Your Honor, even...
I know we're slicing it thinly. Isn't this why we have an ALJ who sits there and is able to work through these intricate facts that I'm throwing at you and resolves them?
Yes, Your Honor. And to be clear, I'm not asking this court to reweigh any evidence in this case. Even if we accept that Mr. Zerby was infected at work by his coworker, I believe that there's a legal standard for the compensability of occupational diseases that is not satisfied.
So you're essentially saying it'd pretty much be impossible for anybody to ever prove a COVID claim, a COVID injury in Arizona, I guess.
I believe that the way that the law is currently in Arizona, yes, that is the case, with a possible exception that it's not before us here that we haven't considered for maybe first responders or medical workers who are exposed to a disease as a natural incident of their job. But this state has a clearly expressed public policy in the occupational disease statute that common diseases to which the general public is exposed are not compensable.
And you started your argument referring to COVID as an occupational disease. COVID-19 is not an occupational disease under the statutes, correct?
It is not a separately enumerated occupational disease, no. And the statute is there to help distinguish between true occupational diseases and these general ailments.
Right.
Which
And COVID is not a true occupational disease.
It's not a disease that arises based on the nature of the employment. I think it's probably the easiest way to say it. As opposed to some of the cases that do deal with this natural connection, like barber, where there's a medical assistant who's exposed to hepatitis in the course of treating patients, or enyart, where there is a nursery worker who is exposed to this fungus in soil that he had to work with to do his job. Or again, the Andreessen case out of Utah that the court in Enyart looked at, where there was a butcher who got some disease that you only get from working around dead animals. Zerby's job here was nothing like those. He was an office worker. He was exposed to COVID at work. He was also exposed to the flu at work, presumably, or the common cold. I mean, these are all diseases that are transmitted similarly to COVID-19. They're all common diseases. They're all ordinary diseases to which the general population is exposed. They are not occupational diseases, and as such, they're not compensable under Arizona's occupational disease rules.
How do you square your argument with the spontaneous fall cases, where compensation is awarded? You're not any more likely to fall at work or because of your job than you are outside of work, and yet the case law says you get an award in those circumstances.
Occupational diseases are treated differently under statute and under case law from accidental injury cases at work. Separate analyses apply to both of them. So to that extent, I don't think that they need to be squared. The Arizona Supreme Court in the Ford case made clear that in cases involving diseases, the parties must proceed under the occupational disease statutes and do not have the option to elect to proceed as if the disease was the result of an accidental injury at work. And this has been the case for as long as Arizona has had a workers' compensation statute. But there have been separate statutes regulating accidental injuries and diseases contracted at work. The reason for that is possibly lost in time or is not something that I'm aware of right now, but there's a separate analysis for how diseases are contracted versus injuries that arise at work.
The legislature has enacted statutes dealing with other communicable diseases like HIV and hepatitis. What should we take, if anything, from the fact that the legislature hasn't enacted a statute like that with heightened proximate cause requirements for COVID?
Your Honor, I think that actually gets close to the point, is that the legislature has not acted to include COVID as a compensable disease. If it wanted to, it easily could, but it has not done so yet. And there's not a way really for this court to distinguish COVID from other common ailments like the cold, like the flu, in a decision. Under the law as it stands right now, COVID is not compensable under Arizona's statutes. Or
How would somebody be compensated on a workers' comp claim for a cold? I mean, this person died. So it's materially different than, oh, he got a cold. He got COVID and he died. So I'm not sure I'm buying your analogy there between COVID and a cold. I guess people do die from colds, but.
Right. Well, the severity of the diseases is vastly different. Right? The consequences of these diseases might be catastrophically worse in one case versus another. But that is a distinction in this case that needs to be drawn by the legislature. The way that these diseases are transmitted, the fact that they're so widespread in the community makes them analytically similar on that level.
Right, but I think you're right. The legislature could step in and say, we're going to treat this like HIV and hepatitis, where they're not really accidents and they're not occupational diseases, so we've stepped in and we've put them into this third category. But the legislature hasn't done that, and so we need to decide whether this is an accident or this is an occupational disease, and I think you've already admitted this doesn't fit, at least within the statutory scheme for occupational diseases, which I think means we're left treating it like an accident, right?
No, Your Honor. The the question is not whether this injury is an accident versus an occupational disease. The question is, this is a disease. Is this a compensable disease? Is it compensable as an occupational disease, or is it simply not compensable because the legislature...
Why is there are only two choices? It seems to me that there's a marked difference between an occupational disease that happens just because of the company versus the lack of procedures or mechanisms or forcing somebody to come to work during a pandemic that raises a whole different inquiry, which puts it more in the accident category.
The Arizona Supreme Court in Ford rejected this idea that disease cases should be treated as accident cases.
What kind of disease was it in Ford? Could you remind me?
Your Honor, I don't recall. But
was Montgomery an accident case? Did they treat Lyme disease like an accident?
Lyme disease was not treated like an accident. Lyme disease was treated like a disease and subject to the occupational disease analysis.
They didn't. Maybe it didn't exist, but they didn't analyze it under the occupational disease statutes.
They did not expressly bring up those statutes. The occupational disease statute lists 6 requirements that an applicant has to prove in order to show that the disease is compensable. There's case law dealing with occupational diseases. A lot of it does not deal with the occupational disease statute requirements. Instead, it relies essentially on those 2 elements that I had mentioned before, excess exposure and causation. Really, the substance of that case law matches the substance of the occupational disease statute. But, Your Honor, to your question as to why this can't be treated as an accident, the statute, ARS 23901, which defines accident by injury, it has 3 different requirements. And the third one does deal with diseases. And there's I'm sorry, I don't have the language in front of me, but it does expressly talk about a distinction between occupational diseases, which are compensable, and diseases to which the general population is exposed, which are not compensable. So that would make that completely irrelevant if you were to say, well, this isn't an occupational disease, it's a general disease, but we're just going to treat it as an accident. I mean, that would find a way to create compensation for a condition that the legislature has expressed a desire not to provide compensation for. In this case, there was not any evidence presented that Zerby's exposure at work exceeded the exposure of the general population. The evidence presented for his exposure was essentially expressed in terms of greater or lower probabilities. And there was no natural connection between Zerby's employment and his contraction of the disease. For these reasons, the award should be set aside. Thank you.
All right, thank you, counsel. We'll now hear from the appellee.
Good morning, Your Honors. My name is Dennis Kurth. I'm with the law firm Snow, Carpio, and Wheatley, and I represent the respondent widow, Diane Zerby. Judge Brown, I think you hit the nail on the head about the facts. There were facts here that were determined by the ALJ, and they're very, very clear, but apparently the petitioners don't accept them yet. Starting with their opening brief where they attacked the facts as the exposure being merely seconds, extremely thin evidence, to their reply brief where their last argument is, once again, the evidence is very weak, it's not legally sufficient to sustain the award. But if you look at the judge's factual findings, if you look at the judge's factual findings, the judge did find that there were at least 2 exposures, one of which for several minutes. So how they can keep arguing that there was a 30-second exposure, that it was extremely brief, it's not the facts found by the judge. And the judge found that there was medical causation. The judge found that there was an actual exposure that was consistent with the incubation period of COVID. The judge found that therefore there was a special exposure, which really means actual exposure. There was no proof of any actual exposures off work. Therefore, just like the Barber case where there was exposures at work but none off work, the judge felt that that met the definition of reasonably medically probable. So we have to agree on the facts. We have to accept the facts as found by the judge unless they're wholly unreasonable, and they're not. They keep arguing this 30-second exposure based on the testimony of a witness named Jeff Vivona, who was specifically found not credible by the judge. The judge specifically found credible the widow, Diane Zerby, and the office manager, Derek Robillard, and putting those facts together, there was sufficient foundation for the opinion of Dr. Schumacher. So
let's say we agree that with the LJ's finding that Mr. Zerby contracted COVID at work. There are two requirements as far as I can see for workers' comp. There's the course of employment and there's a rising under. Once you decide that Mr. Zerby got COVID at work, course of employment seems fairly easy to me. Can you explain to me, though, how this arose under Mr. Zerby's employment and satisfies that particular element?
It satisfies the element of an injury arising from risk related to the employment of Article 8, Section 18 of the Arizona Constitution that requires that there be some risk, the origin of the injury and the risk of the employment. The risk was exactly that, becoming in contact with a person who didn't observe the rules that the employer weekly tried to enforce. That's why this gentleman got COVID at work. He had to go to work. They were not allowing remote work from home. There's a text message in evidence in the file from the employer saying, we don't want people working from home. Everybody come to the office. So you come to the office, you could protect yourself as well as you want at home, like this man did. This man had a kidney transplant. He was very, very afraid of the risk of COVID to his life if he were to get COVID. He did everything he could. The record shows that he and his wife invited nobody into their fifth-wheeler. The wife did all the shopping. They didn't go out in public very often. Yet he goes to work and he contracts this disease because a particular employee didn't follow the rules and the employer didn't enforce the rules. The boss even admitted that. They had a safety guy right in the suite where these people were working, the deceased employee and the person who passed the COVID on. And that gentleman that passed the COVID on came back to work before he got his positive COVID test result. He had been tested, he was sick. The rule was you don't come back to work until you're negative. And he comes back to work for 2 full days, and a whole bunch of other people got infected. So you can protect yourself at home, but you can go to work and you're captive to the environment at work. This is very, very common. I mean, I can tell you in offices like mine, COVID went around very rapidly if rules are not enforced. So I think we've got to accept and we've got to defer to the findings of the judge. They're not wholly unreasonable. And if the petitioners were to accept the facts of the multiple exposures with a time factor clearly enough to transmit the disease, there is a reasonable basis in the evidence for the judge's findings. Now, the law then is another issue. In the opening brief, you see that the petitioners are arguing that as a matter of law, COVID cannot be considered a compensable workers' comp disease because under the valley fever cases, prevalence of valley fever in an area disqualify it from coverage. That's not what happened in the Treadway case. The claimant in Treadway and all the valley fever cases, the claimants did not lose those cases because the disease was widespread. They lost those cases because that disease is passed in the air by microscopic little spores that nobody can tell when you came in contact with those spores. So those claimants in the valley fever cases, they lived in areas where valley fever was endemic, and it was impossible for them to prove that. That's where this issue of special exposure comes from. It comes from Treadway. And Treadway added the phrase special exposure in excess of a commonality. And I think what's going on here is petitioners are reading too much into the word commonality. What the court was talking about, and this is illustrated in the O'Connor case too, it's not some comparison of the general public's risk of getting COVID in Arizona to the risk of getting COVID at work. That's completely meaningless. If you try to figure out how you're going to assess the risk of the general public at work, at this particular workplace, versus not at work, what do? Do you hire a statistician, a sociologist, or whatever? This case was prosecuted and tried as an injury by accident under the statute, not an occupational disease, but an injury by accident. And we met the burden of proving our case as an injury by accident. If you look at it from the point of view of us having to prove that the exposure was in excess of the commonality, and you accept petitioner's argument that you can't look at Mr. Zerby's condition, the guy who really tried to avoid COVID off work and then ironically got exposed at work, you can't win that. So you would have a case like the Lorenzen case. I urge you to look at the Lorenzen case because that is a case where the exposure was coincidental to work. It was pesticides being sprayed around a school that got a teacher sick. The exposure was purely coincidental, but that was held to be litigable as a injury by accident rather than an occupational disease. The court in Lorenzen actually said that the ALJ found that the teacher was equally exposed to pesticides off work. That would have defeated her claim for a accidental injury on that case. How can you let that happen? How can a person prove an exposure at work, prove they contracted the disease within the incubation period, and then say that now your claim is not compensable because you can't prove that most people in Arizona are not exposed to these diseases at work more than they are at home. That would be a meaningless statistic. So basically, this case law is old. This Treadway case goes back to 1950, and that's where the special exposure came from. And special exposure under Treadway basically means causal connection. That's what they're looking for. That's what's missing in Treadway and all the valley fever cases. The O'Connor court said there must be a causal connection between the employment or the place of employment and the illness. Something which happened to him in the performance of his duties or some contact he made at his place of employment while on duty that provides the connecting link. So we've proved that. It doesn't make any sense to interpret the phrase commonality because all that's going to do is lead to the conclusion that the claim is not compensable if you follow petitioner's reasoning. But once again, how can you possibly compare a kidney transplant immunosuppressed recipient with anybody else in the general population? That person, this person, Mr. Zerby, took the precautions to avoid COVID at home. But he goes to work and some guy doesn't follow the rules, and pretty soon he dies a pretty nasty death within 2 or 3 weeks. This is a serious problem. By October of 2020, when Mr. Zerby was exposed to COVID, employers had 7 months' notice then to provide mitigation measures, and a lot of them did. This was a fairly good-sized employer. but they didn't enforce their mitigation measures, and an innocent man died an unnecessary death because of that. This should be covered. Public policy is in favor of covering this, not against this. Petitioners talk about public policy, but you have to consider the other side of this coin. Here's the workers' comp carrier for this employer essentially arguing, hey, this should not be covered by workers' comp, so go ahead and let the claimant file a lawsuit against us or the employer for contracting COVID because they didn't enforce the rules. There's been a lot of lawsuits, as we know, against nursing homes, hospitals because of COVID, and this employer would have been subject to those civil liability penalties or damages had this not been covered.
Does your client's claim rise or fall on how effective the policies were and whether they were being enforced?
I don't think it rises.
I don't want to say that, for example, an employer who didn't have a vaccine mandate is therefore on the hook for workers' comp.
No, I don't think it rises or falls at all, Your Honor, but I think in this particular case, it provides some helpful information to understand how this man got COVID, and ironically, how worse off he was by being at work as opposed to being at home like the general population. So we litigated this case under the law. We're allowed to claim and litigate a disease case, outside of the occupational law. The definition of personal injury by accident was expanded in the workers' comp law in the early 70s, so this case fits right in there. It's not an occupational disease because it's not peculiar to the occupation. What the petitioners want is they want all these claims non-compensable because they don't meet the occupational disease standards. They talk about legislation in the last part of their reply brief. Larson proposes legislation. You want to keep COVID coverage, obviously, for first responders, medical people, hospital people, people who work at the state prison. These are very serious claims. I assert to you that unless you've seen other of these COVID claims up here, there is no explosion of these cases. But there are some very, very serious cases. I have another one where the guy ended up with a heart transplant. This is very, very serious business, serious injuries. There's no reason not to cover them, especially as injuries by accident outside of the workers' comp law or the occupational disease law. And that public policy does support that, rather than telling these employers that, hey, you can go protect yourself with liability insurance because you're going to be subject to lawsuits. So there's a balancing act going on here. The other thing is the petitioners say that the legislature has already evidenced a feeling that these kind of diseases should not be covered. I submit that that's not exactly what happened. The legislature instead has exhibited a desire to have these diseases covered as injuries by accident, and that's why they changed that statute, 23901, back in 71. So they were trying to expand the coverage of these diseases, not limit the coverage. So the legislature can do whatever they want. The petitioners can go to the legislature. The legislature is very amenable to changes in the workers' comp law if they want to do it. But there's obviously got to be coverage from COVID to some respect with injured claimants, especially on very, very serious injuries and death claims. And the public policy, of course, is to provide coverage to assist injured workers, to help them get medical treatment and rehabilitation, and help them protect themselves as well. So go to the legislature, change the law. There could be all kinds of horse trading involved as to who's going to get covered and who's not. But this case was litigated under the law. The fact findings all solidly support the judge's award. We do not have to prove that exposure to COVID was part of the process of the employer's business, just like Lorenzen didn't have to prove that pesticide spraying around the school was part of her daily exposure on the teacher job, nor that Lyme disease, which of course the court in Montgomery said was a purely random happening, a coincidence, yet still compensable. We don't have to prove that. That's a burden of proof for occupational diseases. That's why the court said special exposure. What that means is actual exposure with contraction of disease within the incubation period and no other potential causes. Everything was met. The case was litigated fairly under the law as it presently stands. And I submit to you that the judge's fact findings ought to be deferred to, and the award is supported by more than reasonable evidence in the record. And I'm happy to answer any further questions.
Yeah, thank you, counsel.
Thank you.
Any final words?
Just two things, Your Honors. First, the respondent has asked if what kind of evidence would be needed to show that a petitioner was exposed, or excuse me, that a claimant was exposed in excess of the general population, and he asked whether a statistician or a sociologist would be necessary. The answer is yes, or at least something like that. Again, the case on point is Montgomery, and in that case, the claimant did present evidence. It was a pamphlet from the an Arizona government agency on tick-borne diseases that provided evidence that the type of tick that carries Lyme disease is not found in Arizona. No such evidence was presented in this case, even though the defendants requested factual findings as to that, both in post-hearing memoranda and in the request for review. No such evidence was presented, and the presiding judge made no findings on that issue. Second, Your Honor, going back to the Ford case involved a respiratory infection that a worker had contracted after years of working in dust for Phelps Dodge Corporation. But that opinion, again, clearly indicates a policy not to extend coverage for common diseases, and that all disease claims...
I was hoping you might address a case that came down prior to Ford, which is Riley. And in Riley, this court said, we find that our law in Arizona is that when a condition has developed, not instantaneously, but gradually over a period of time, resulting in a definite, though unexpected injury or disease, which injury or disease is definitely work-connected, then said injury or disease is the result of an accident within the terms of our Workers' Compensation Act and is compensable. And then Ford says, well, we have this other occupational disease statute, and if one of the two parties wants to elect to have the claim proceed under that, those provisions, it can. But as far as I can tell, that didn't happen here. And so I think we're in the accident, we're under Riley.
Your Honor, Ford does not make it permissible. In fact, it expresses its conclusion in mandatory language. An occupational disease claim must be pursued under the special statutes pertaining to such claims, rather than under the sections pertaining to injury by sudden traumatic event.
Right, but it approves, the very introductory of the opinion approves a statement in our case in Phoenix Pest Control, which says, under our present statutory scheme, when the condition giving rise to the claim for workman's compensation benefits is a disease, either party is entitled to require that the claim be administered pursuant to the provision of the Workers' Compensation Act governing occupational disease. And that didn't happen here, right? Your client did not require that this claim be adjudicated under the occupational disease statute.
That's correct, Your Honor. Instead, we raised the substantive arguments expressed in that statute as raised by a lot of the case law that we've already discussed today. And as I've argued, that case law indicates the COVID-19 should not be found compensable. Thank you.
All right, thank you. The matter is deemed submitted. We'll issue a decision in due course. The court is in recess.